Good afternoon, everyone, and welcome to our meeting of the Standing Committee on Justice and Human Rights as we resume our study into mental health and other support to jurors. And we are delighted to be joined today by an illustrious panel. I'll start with the people that are here in this room. Testifying as individuals, we have Mr. Patrick Bailey. Welcome, Mr. Bailey. We have Ms. Marie-Ève Leclerc. Welcome.
Thank you.
And Ms. Michelle Lonergan. Welcome.
Thank you.
And Mr. Greg Kylo, who is the National Director of Program Innovation of the Canadian Mental Health Association. Welcome.
Thank you.
And testifying by video conference from Toronto, we have Ms. Vivian Lee, who's a psychologist, testifying on behalf of the Center for Addiction and Mental Health. Welcome, Ms. Lee.
Hello.
So we will ask you all to present. It's 8 to 10 minutes by group. And we're going to start in the order that we have the witnesses on the list. So we will start with Mr. Bailey.
Thank you, Mr. Chair, and thank you for the invitation to present. Yesterday, you heard from Madam Justice Sheila Martin, who was my law school ethics prof. And one of the things that Sheila didn't talk about was a particularly difficult case that she had had a few years back. Dustin Paxton was charged with incredible abuse of his roommate, to the point that when the roommate was dropped off at the hospital in another province, he was so disfigured it took the hospital days to figure out his identity. Multiple experts, including myself, were involved in the case. Court clerks, police officers from 2 provinces, lawyers, and Madam Justice Martin herself. All of those individuals had access to mental health supports afterwards, and I know in varying degrees each was impacted by that particular case. Imagine then the scenario where an envelope shows up in your doorstep summoning you to jury duty. You're not an individual who typically spends much time in the justice system. You're not a member of the media. You're not a member of the legal profession. But you're compelled to show up and take responsibility for determining the fate of one of your fellow citizens. You're not appropriately compensated for that. In Ontario, there's no pay for the first 10 days that somebody serves on jury duty. In Alberta, we'll pay you $50 a day for showing up for jury duty. Every province, to my understanding, has a minimum wage standard, but we don't pay even the minimum wage to the jurors who are showing up to provide that responsibility. In fact, in some provinces, they'll even have to pay for their own parking. Childcare, other sorts of related expenses, those stresses start to add up. So the first thing that people do when they receive their jury summons is start thinking about, how can I get out of this? And so we end up with a situation where effectively people who are members of unions or people who are well paid in their other practices through passive income, for example, are the only folks who are able to serve on juries, hardly a jury of one's peers. And then imagine a trial such as either one of the 2 gruesome trials we had in Alberta earlier this year. Douglas Garland charged with the murder of the grandparents, Alvin and Kathy Lickness, and their grandson, Nathan O'Brien. Or Derek Saretsky charged with the murder of 3 individuals in southern Alberta. Each of those was a jury trial. Each of those lasted for weeks. Each of those involved graphic testimony. In the case of the Garland trial, there was evidence that Mr. Garland had hung the victims on a meat hook, which was subsequently tested for DNA that showed the presence of the victims. That meat hook was passed around, albeit in a plastic bag, from juror to juror, with the sound of the thud on the table as it moved through each of the participants. It's not surprising then that while people are thinking about the financial impact or the scheduling impact of serving on a jury, they don't spend as much time thinking about the mental health impact of serving on a jury. But we know, as my colleagues will tell you, some evidence points to the occurrence of post-traumatic stress, symptoms of anxiety, depression, anorexia, sleeplessness, and other forms of nervousness. And then at the end of the trial process, you're told in some provinces you may get access to 4 sessions of counseling over the next 2 months, or you may not get access to any sorts of counseling. But the very first instruction that a juror is given when they start their responsibility is the instruction from the judge that they are not to discuss this case with anyone other than the members of the jury when they are all present. So you heard 2 weeks ago the compelling stories of 4 jurors who sat on lengthy trials. And Mark, for example, is not able to talk to his friends or family members about what he's going through. When you and I have a bad day and we want to find some way to debrief and unwind, we talk to a spouse, we talk to a family member, we talk to a close friend, we may talk to a psychologist or other therapist. That's the way that we unwind, but jurors are specifically told that that tool's not available to them. In the Garland trial, we had Justice David Gates going out of his way to look after the mental health of the jurors. But now that caution, that support for the jurors, is actually one of the grounds that's being used in the appeal as suggesting that he was biased in his rulings by being so protective of the jurors' mental health. So we end up in this situation where we don't tell people what it is that they're getting into. We don't support them when they're in the process, and we give very limited support to them after the process. So what I'm proposing to you is a series of steps, and I'll put a formal document before you over the next little while, that deals with the information that should be provided to jurors before they get involved in jury duty, that reminds them of their own resiliency skills and the things that they typically do to look after themselves. It gives them more information about things like voir dires that are going to disrupt the trial process. So there may be days when they're not called to be there, and they have absolutely no information about what's going on. About some of the mechanics, about who's going to pay for parking and what sort of compensation they're going to receive. And then during the trial, a process that allows those people to have access to a counselor, a psychologist, or other therapist who's been appropriately designated by the province, who doesn't talk about the trial, but provides support to those jurors who may be in lengthy trial processes, about making sure that we have adequate compensation so that there isn't a financial stress that goes along with that. And perhaps in some of the longer trials, even thinking about having a mandatory break. You heard about a juror who served on a 10-month trial. There isn't a vacation break along the way. Nobody paid them to take a week off and not come in for jury duty. And yet everybody else who would typically be involved over a process of that length of time would be allowed to have a vacation. And then the things that we do afterwards. Juries, as you well know, are never allowed to discuss the deliberations. They're never allowed to talk to anybody about what happened in the jury room. But I can tell you that some of the jurors who've approached me over the last couple of years who've sought out counseling because they found the provincial programs to be lacking have talked about how stressful that part of the process was. You've impartially listened to all the witnesses. You've heard the evidence. You've handled the exhibits. And when you get into the jury room, some of them have told me, there's been a unanimous decision about what the verdict is going to be, but then a lengthy discussion over hours and even over days about how each juror reached that particular decision. And the deliberation process, we know from some of the limited research on jurors, can be just as stressful as the rest of the process. So again, what I'm proposing to you, if you look at Section 10 of the Divorce Act, it allows for a judge to nominate an individual who would assess whether or not there's any possibility of reconciliation for this couple. And the information that's disclosed during that assessment process is never compellable in any other setting and cannot be disclosed even with the consent of the husband and wife. A similar condition that would allow jurors with a designated service provider to talk about everything that they've been involved with would then start to do the things that we need to do to look after the jurors' mental health. I look forward to answering your questions. I'm happy to talk more about this. It's something that I've advocated on for years, and I greatly appreciate the committee's interest in taking on this topic at this particular time. Thank you.
Thank you very much, Mr. Bailey. I will move on to Ms. Leclerc and Ms. Lonergan.
All right, so I'll begin. So good afternoon, members of the committee, and thank you very much for inviting me here today to discuss the very important topic of juror mental health. I'm a fourth-year PhD candidate in the Department of Psychiatry at McGill University, and for the past 9 years I've been studying the devastating effects of trauma and post-traumatic stress disorder under Dr. Alain Brunet's supervision in his Laboratory on Psychological Trauma at the Douglas Research Center. And I'm here today with my colleague Marie-Ève Leclerc, who's a current PhD student in the School of Psychology at the University of Ottawa, a former master's student with Dr. Brunet in the Department of Psychiatry at McGill, and co-author on the research that I'll be presenting today. In September of 2014, the trial of Luca Magnotta, a man who murdered Concordia University student Lin Jun in the spring of 2012, began. That same month, my supervisor, Dr. Brunet, expressed his concerns in an interview about the increased risk for PTSD among the jurors, the lawyers, the expert witnesses, and other court staff that might be present and witness violent material during Magnotta's trial. This marked the beginning of Dr. Brunet's interest in examining the potentially traumatizing effects of jury duty. An important caveat is that about a year prior, the 5th edition of the Diagnostic and Statistical Manual for Mental Disorders was published. And in it, the definition of what constitutes a traumatic event was broadened and now includes individuals who are indirectly but repeatedly exposed to violent material through photographs and videos, typically in the course of their professional duty. This was not included in prior versions of the DSM. And what this means is that the American Psychiatric Association now recognizes that any individual who is repeatedly exposed to violent and graphic material, such as a juror, can be at risk for developing post-traumatic stress disorder. With the idea of building a research study investigating this question, Dr. Brunet asked me to write a paper that systematically reviewed the scientific literature on juror mental health, the results of which were published in 2016 in the Journal of Criminal Justice. In total, we located 14 studies published since 1985 that examined post-traumatic stress symptoms as a result of jury duty. This research revealed that as many as 50% of the jurors will experience moderate to severe PTSD symptoms that could benefit from clinical intervention. Up to 12% of these jurors might be diagnosed with PTSD right after the trial, which can persist in some individuals for months and maybe even years. The most consistently reported symptoms across the studies that we reviewed include intrusive thoughts, memories, and nightmares about what they heard or what they saw, difficulty sleeping and insomnia, a lack of appetite, feeling emotionally numb and disconnected from their surroundings and from their loved ones, and hypervigilant of their surroundings, so feeling constantly on guard and afraid. Other research demonstrates high rates of depression and anxiety, in addition to substance use problems, which often complicate the PTSD profile. Our review also highlights several sources of stress among jurors, the most prominent being factors related to the deliberations. These include deciding on a verdict, fears of making the wrong decision, tension between jurors, and being isolated from familiar support networks. The nature of the trial was associated with severity of pathology across the studies, with 30 to 50% of jurors reporting that gruesome evidence was at least moderately stressful. Jurors on criminal trials involving crimes against a person consistently report more severe PTSD symptoms and are significantly more likely to be diagnosed with probable PTSD and major depression compared to those who sit either on non-criminal trials or on criminal trials that involves a crime that is not committed against a person, such as burglary or credit card fraud. Other research suggests that the length of the trial, in combination with the presentation of graphic evidence, carries the highest risk for PTSD among jurors. The literature also highlights that jurors with a history of mental health disorders, especially those who are faced with a case that is relevant to their own personal and prior trauma, are at increased risk for PTSD following their service. Although the research to date supports the idea that the risk for PTSD might be highest among jurors who sit on high-profile trials involving violent crimes against the person, the strength of our findings should be considered in light of several methodological limitations, specifically and, for example, regarding how trauma and PTSD are measured and diagnosed across and between studies. I'm happy to elaborate on these issues during the question period. But for now, I'll turn it over to my colleague, Marie-Ève Leclerc, who's here today to offer some recommendations based on our work, as well as answer any questions regarding her experience with attempting to conduct a study on PTSD among former jurors.
Thank you, and thank you for inviting me here today. I was involved in designing a study that aimed to evaluate PTSD among jury members that's seated on a very specific criminal trial for my master's degree. Unfortunately, Due to several obstacles, I was unable to complete this research. To maintain the focus on trauma symptoms in the courtroom, I conducted a study on PTSD among Canadian lawyers instead. I would be happy to answer questions about those results in the question and answer period would there be an interest. Based on this experience and the work that was presented here with Ms. Lonergan, I would like to discuss the following recommendations. The following recommendations are for planning a research study. We believe that in order to engage in active problem solving regarding this issue, we must extend beyond the courtroom. For example, to employ a multidisciplinary team of academic experts in the field of psychiatry, psychology, and the law, with the goal of building bridges and addressing the limitations of prior research. Research could be directed at evaluating potential jurors for psychiatric disorder prior, after, or several months following the trial. These clinician-led evaluations would help us understand the scope as well as the progression of the problem. This would not only help us build a profile to identify who is more at risk for trauma-related disorders as a result of their service, but it would also shed some light on the direct effect of jury duty on mental health. The following recommendations are for addressing juror mental health. Post-trial debriefing is sometimes used by judges to help buffer the detrimental effects of jury service on mental health. Despite the judicial system's commendable efforts to mitigate symptoms of stress in jurors with the use of post-trial debriefing services, evidence revealed that debriefing alone may be insufficient to reduce the levels of pathology among those jurors. Like for many treatments, combining several evidence-based practices would likely result in optimal outcomes. This could include the use of psychoeducation on self-care and adaptive coping mechanisms for preparing the jurors to face the potential traumatic material. This would also provide an opportunity to elaborate on the psychological services that would be offered to the jury members. It could also include counseling and debriefing led by mental health professionals throughout the trial, as a group or individually. It is our belief that mental health disorders are best addressed by mental health professionals. Moreover, clinician-led debriefing and counseling post-trial for an extended period of time would be highly beneficial. Post-trial extended follow-ups could be conducted weeks or months following the end of a trial in order to reach out to jurors and ensure their proper rehabilitation, as many individuals do not seek help for trauma-related disorders. Lastly, Section 649 of the Canadian Criminal Code prevents former jurors from disclosing information related to the judicial process, which restricts in-depth investigation into the true experience of Canadian jurors for research as well as for clinical purposes. It would be highly beneficial to amend this section for licensed mental health professionals that are mandated by confidentiality policies, or having psychologists that are under oath, specifically working for the court, that can assist the jurors throughout this process, as mentioned by Dr. Bailey earlier, as designated service providers. In conclusion, we are delighted to hear that the House of Commons is initiating research investigating this very important matter, and we are honored to share our findings with you today. Thank you for your attention.
Thank you very much, ladies. And now we will go to the Canadian Mental Health Association, Mr. Kylo.
Thank you, Mr. Chair. Good afternoon, members of the committee, colleagues. Thank you for inviting me here today. My name is Greg Kylo. I'm the National Director of Program Innovation with the Canadian Mental Health Association, the national office. We're celebrating 100 years in 2018, and CMHA, as you may not be aware, as we're often confused with CAMH, is the largest community-based mental health nonprofit in Canada. Even within the sector, it's sometimes overlooked that CMHA has an active presence in more than 330 communities, with almost 5,000 staff impacting the lives of more than 1.2 million Canadians per year. CMHA is the only national community mental health organization that is inclusive of all diagnoses, all professions, and all demographics. Thank you for your attention to this very important issue. The mental health of jurors needs to be protected, and measures need to be in place to ensure that duties of being a juror and contribution to justice in our country is not a detrimental cost to the jurors' well-being. Today, I'd like to focus on key areas that we believe will speak to the importance of protecting the mental health of jury members and how these services may be best positioned within the justice system. We at CMHA applaud the federal government's commitment to addressing the mental health of jurors. The impact jury duty can have on participating citizens needs to be understood more thoroughly, as well as the serious mental health issue that many people associate with first responders or soldiers engaged in combat operations. But we know that occupational stress injuries, or OSIs, and post-traumatic stress disorder, PTSD, can be developed for a myriad of reasons, and these reasons are often very subjective. The negative effect of a difficult trial can be felt by anyone participating in a legal proceeding, and we're hopeful that over time we can ensure that all parties are protected from the harmful impact of OSIs and PTSD. We encourage making mental health supports available to all individuals involved in our justice system. CMHA National encourages the justice system to collaborate with community mental health agencies and find effective solutions for occupational stress injury and post-traumatic stress disorder amongst the participants in all courts in Canada. CMHA branches across the country are prepared to assist local courts in the rollout of any programming designed to address OSIs and PTSD within their communities. As has been articulated, and as you are aware, occupational stress injury is any persistent psychological difficulty resulting from operational duties, such as law enforcement, combat, or any other service-related duties. PTSD is a type of OSI which presents after an individual has experienced a particularly harmful event known as trauma. While OSIs and PTSD are often associated with veterans and soldiers engaged in combat operations, they can be developed in other circumstances, such as within jury duty. Jury members, lawyers, survivors of violence and crime, police officers, paramedics, children's aid workers, nurses, doctors, and humanitarian workers are examples of individuals who are exposed to primary or secondary trauma in the course of their work. PTSD is one of the most common types of OSI and can present as depression, anxiety, substance misuse, and other mental health symptoms that persist and disrupt daily life. PTSD has a range of symptoms such as flashbacks, nightmares, the development of phobias, depression, irritability, anger, and sometimes self-harm and suicide. Trauma is a very subjective experience. Which means that certain events may trigger the development of PTSD in some individuals, but not in others. Trauma can have physical, mental, and emotional components. One can also experience secondary trauma or secondary traumatic stress, which is experienced when one witnesses or hears about another's trauma and hasn't necessarily experienced it firsthand themselves. Listening to the lived experience of those who have served as jurors is a critical step in guiding action and provisions to identify what is required to protect and preserve the mental health of those who serve in our Canadian justice system. I'd like to acknowledge and thank those with lived experience of mental illness and involvement within our justice system who have contributed to this discussion. What we have learned is that there are certain types of trials that pose more of a risk to the juror, and the nature of the trial must be considered. In the case of murder trials, the compounding effects of listening to details of crime, viewing evidence such as autopsy photos, passing judgment on offenders' guilt has left jury members emotionally distressed. Seeking help is often left to the individual and voluntary. In the case of jury duty, standard practices of care must be embedded within the jury duty responsibilities and should be considered mandatory safety precautions. We recommend that the Department of Justice establish enhanced protocol on the psychological protection of jury members. Jury members should be informed that participating in such safety protocol before and after jury duty are expected in order to ensure the safety and well-being of jurors. Should these services be mandatory? Wearing safety protective gear is mandatory in some workplaces. In the case of jury duty, when jurors are exposed to highly traumatic material, this produces an extremely unsafe environment. Therefore, we recommend considering mandatory measures be established to safeguard against harm in certain trials. It should not be left up to the individual jury member to apply to the Criminal Injuries Compensation Board for reimbursement for costs of treatment, lost wages, and other expenses following trauma and psychological injury of serving as a juror. Programs including jury debriefing and post-counseling should be provided free and easily accessible, and that accessibility is really the key to ensuring anyone serving serving jury duty. The federal government should consider following provincial justice departments such as Ontario, where jurors are able to call a designated phone number 24/7 to get help whenever they need it, and Manitoba, where a jury debriefing program is a best practice and has been implemented successfully. These programs would benefit anyone who has served in a criminal or civil trial or an inquest. Jurors will be provided with information on the program at the beginning of the trial and then again as it finishes or as needed throughout. In conclusion, I want to recognize that although there may not be many studies or significant landmark trials done on the psychological impact to jury members to date, we do have evidence of the lasting effect of occupational stress injuries and the importance of minimizing exposure to harm. If individuals have been exposed to stress or significant traumatic material, we do have evidence-based tools to support the person to manage this exposure and address their emotional and psychological needs. I urge the Canadian government to not wait until there is mounting evidence that certain practices such as debriefing and post-trial counseling are proven in the context of jury duty, but to act now and make these evidence-based practices readily available, accessible, and compensated. Thank you again for inviting me here today. Thank you.
Thank you very much, Mr. Kylo. And now we will go to the Center for Addiction and Mental Health. Ms. Lee, the floor is yours.
Thank you, Mr. Chair. And thank you to the Standing Committee on Justice and Human Rights for the opportunity to discuss mental health supports for jurors. I'm a clinical psychologist who has worked with many individuals who have experienced trauma in their line of work, including first responders and military members. What many of them have in common are not only mental health injuries as a result of exposure to trauma, but also the confusion and stigma that they're suffering as a result of something that's considered a normal part of their duties. Therefore, they often do not recognize or seek help until much later when their difficulties have impacted many aspects of their work and personal lives. Why is this important to the Canadian government? In addition to the amount of suffering of individuals and loved ones, the Mental Health Commission of Canada has estimated the cost of mental health difficulties to employers in Canada to be $6 billion in lost productivity per year. And 30% of short-term and long-term disability claims can be attributed to mental health difficulties. Imagine if we could make a dent in that economic cost, an incredible amount of suffering. We can certainly do so by improving awareness and increasing early access to effective treatments to reduce this ripple effect on our economy. The World Health Organization estimates that every $1 invested in treatment for depression and anxiety results in a return of approximately $4 on better health and ability to work. Returning to the impact of trauma on mental health, I'd like to highlight the impact of cumulative trauma, or the repeated exposure to traumatic material and human suffering. For example, criminal investigators may have to repeatedly view extremely disturbing and graphic images and videos over and over. They may bear witness to extreme suffering and work with victims and their families. The impact of exposure to such material can induce feelings of horror and helplessness, and was included in the revised criteria for PTSD a few years ago. Repetitive exposure to traumatic, gruesome details, as well as witnessing the emotional impact on victims, their loved ones, and witnesses, can certainly impact those in the courtroom as well. Members of a jury have no choice as to whether they serve on a jury or the type of trial. Similar to investigators, jury duty may involve exposure to horrific images, videos, and details of unspeakable horrors and immense suffering. Yet, presently, jurors do not receive any education on the potential impact on their own health. Similar to first responders and others exposed to trauma in their work, jurors may try to suck it up and fulfill their civic duties. They may not recognize that they're struggling until they've finished and return to their regular routines. There, they may begin to see the impact on their emotional and physical functioning. PTSD symptoms may include, but are not limited to, repeated disturbing memories and images, nightmares, feeling jumpy, trouble sleeping and concentrating, feeling numb, guilty, sad, scared. And they may try to cope by drowning out these problems with alcohol or drugs. Imagine experiencing these types of problems day after day, night after night, seeing horrible images when you look at your computer screen, or worse, the face of your loved ones. I worked with an individual who was severely impacted by his service as a jury member. He was repeatedly exposed to horrific images and details of the victim's suffering throughout the trial. He performed his civic duty well. However, he developed PTSD. Of course, he had no idea what was happening because he knew nothing about PTSD, except it was something that happened to soldiers and victims of terrible crimes. He never imagined that his difficulties may be the result of a regular societal role of serving on a jury. His home life deteriorated and his work suffered. When he tried to reach out to the justice system for help, he received few answers. By the time my client realized something was wrong, that it was connected to his jury duty, and he eventually made his way into my office, at least a couple of years had gone by, and his PTSD symptoms were now well entrenched and impacted every single aspect of his life. There are now many other stressors to deal with on top of his PTSD. And treatment was also a major financial burden for him, resulting in fewer and irregular sessions. If he had knowledge of how trauma could impact jurors, guidance in accessing services sooner, and financial help in paying for evidence-based treatment, he could have started to feel better much sooner, and many of these ripple effects may have been avoided. This brings me to evidence-based treatment for PTSD. This term evidence-based is important. There are many counselors and therapists out there who offer therapy for trauma, but their effectiveness varies widely, and some may be ineffective or even worse than one's PTSD. It is crucial that evidence-based treatment be available, both for the client to access effective care that can help him or her, as well as reduce long-term costs for the payer of the treatment. The American Psychological Association recently updated their guidelines for best practices in PTSD treatment based on strong research support. These include treatments such as cognitive behavioral therapy, prolonged exposure, and cognitive processing therapy. These treatments have also been studied and recommended by the National Center for PTSD, run by Veteran Affairs in the US. In summary, there is a similarity between jurors serving their civic duty on trials and criminal investigators bearing witness to traumatic scenes over and over. Recommendations for this standing committee include: 1, providing jurors with education about the potential impact of traumatic material, as well as resources for healthy coping skills before and throughout the trial. This can also help to reduce stigma. 2, provide psychological information and check-ins after each trial so that individuals can recognize if they do begin to experience trauma-related difficulties. Such a process would let individuals know that experiencing intrusive symptoms like memories and nightmares for the first few weeks is normal. This process would not ask individuals to go into detail about the trauma, as this can be harmful too soon after the experience. 3, because many individuals may not notice problems until they've transitioned back into their regular lives, it'll be important to provide contact information for a specific organization or individual should the individual need guidance in accessing services. And 4, having funding available for evidence-based treatment can make an incredible difference, short-term and long-term. Thank you, members of the committee, for allowing me the opportunity to speak today about the impact of trauma on jury members. Having a federal framework in place to support members of our society performing such an important civic duty will be remembered as a crucial step forward in promoting mental health for Canadians as a whole. Thank you.
Thank you very much, Ms. Lee. And now we're going to go to questions. So just because you can't really see what's going on in the room, we're going to be having questions to any of the different witnesses, whether in the room or you on video conference. And we'll go in order. We'll do a round of questions, and then I'll open it up to any questions. So we're going to start with Mr. Nicholson.
Thank you very much, and thank you very much for this testimony. This was very powerful. It was right on the money, and is very much appreciated. I hope both Ms. Leclerc and Ms. Lonergan, that when you produce your thesis here, I hope you send a copy to us here at the Justice Committee here. Believe it or not, over the years, I've read a number of theses on issues that I'm very interested in, and so we would certainly appreciate it if that's possible. Dr. Bailey, I had a feeling you could almost write this report for us right now, and you seem to cover off everything, and you said that you're going to be forwarding material to us. That would be very welcomed. I just want you to know. You touched upon, I think, all different aspects of this, and one of the things you said, among other things, we would let jurors know that among what, if anything, they're going to get in terms of compensation. I mean, I'd almost be embarrassed to tell some of these jurors just what they're going to get, trying to explain to them how important their role is, but you'll get nothing for the first 2 weeks here, and you may get $50 a day after that if it goes for a couple of months. So what are your suggestions on that, or what thoughts do you have on that? Wouldn't this contribute to these individuals? I mean, you made the point, a very good point, that when people get these notices here, what do I do to get out of this? That's number one. But isn't this another way of letting these people know that they are not being treated 100%? They're not going to be treated well under the system? Doesn't that send the message?
And sir, I saw you nodding when I made the comment about the minimum wage. I don't think this is a minimum wage job. We're asking people to all of a sudden become experts in criminal testimony, in evaluating the quality of the evidence that's put in front of them. And as my colleagues have pointed out, jurors don't have the option of looking away. They can't take a 15-minute coffee break in the middle of somebody's testimony. And so I think a minimum wage is an absolute minimum, and we need to be looking significantly higher than that. So if you assume $15 an hour in a regular day, because I don't really expect people to go to work after they've served on jury duty, then you'd be talking in the range of $100 to $120 a day as an absolute minimum. But I think, and if I may, just a quick biography. I've been a psychologist. I've been working with the Calgary Police Service for 22 years. I've been working in an outpatient forensic program for 25 years. Because of the outpatient forensic program, I had judges who said, you know, if you want to understand how to think like a lawyer, you need to become one. So the doctorate wasn't enough. I went back and did law school afterwards, you know, just for fun.
Good.
And so I'm a psychologist and a lawyer, and hence part of the reason that I see this from a number of different perspectives. But I've also been privileged to have the conversations with the judges and the lawyers over the years about how these cases impact on them. And then more recently, jurors who sought me out, frankly, because of the amount of media attention that's been brought to this issue and the opportunity to discuss it. So I think the supports that we need to put in place begin with the finances. But as my colleagues have suggested, it's something that needs to continue afterwards. And 4 sessions within a 2-month period simply isn't enough.
They might not have the symptoms for 2 months.
As Dr. Lee suggested, it could be the years later that the individual develops the symptoms. As Mark told you, it was months later before family members noticed that he just wasn't getting back to being his regular self. And Mark's advocacy on this has been absolutely instrumental in getting people to pay attention to it. And so the finances are part of it, but having qualified evidence-based therapy from qualified therapists on an ongoing basis is critical. Yeah. I did a CBC segment a couple of weeks ago, and the director of the Alberta program was invited to participate in the conversation. She said over the last 2 years that the program's been in place, they've had about 20 jurors access the program. Well, even if you assumed the 4-session maximum for them, even if you were paying the therapists $200 an hour, that would be a $16,000 bill to run the program for the entire province. So for a minister to suggest that this has significant cost implications, they're not paying attention to the mental health of the jurors.
Ms. Leclerc, you made a very interesting suggestion to us, and one that is right up our alley, and that was making a possible recommendation to change the criminal code. I mean, I don't know of any other information that somebody can get that they would never be able to discuss it with anybody else. I mean, and so in your suggestion, and I'm hoping we will move forward on that, is to look at that section of the criminal code and say, just a second, it is possible to share that information with somebody in the medical profession, and so thank you very much for that. Did you have any other comments on that?
Not particularly. Perhaps Ms. Lonergan does?
I can tell you what I was going to ask you, Ms. Lonergan. Is that you said that there are a number of different measurements between on PTSD and a number of different studies here. I wonder if you could explain just a little bit more. You didn't.
Yeah. So as a trauma researcher, I found it quite daunting to review this literature. Many research studies that are out there use validated measures of post-traumatic stress disorder. So I approached this exercise or this paper saying, okay, I have a specific question. I want to know to what extent do jurors meet PTSD diagnostic criteria or exhibit symptoms following a gruesome evidence. And so those were pretty much my search terms. What I ended up finding was that although a lot of the studies employed standard measures of post-traumatic stress disorder, many of them were modified to such an extent that I was reading it and I said, okay, well, what does this mean now? When you want to compare this to other PTSD populations, it becomes uncomparable. Or, for example, they would report prevalence statistics of the diagnosis of PTSD, but you have no idea how long the symptoms have been lasting for. Some research omitted criterion F from the PTSD diagnosis, which refers to functional impairment, so your inability to function at home, at work, or at school. Some studies said, well, the prevalence was 10% of PTSD, but we didn't take into account this. We just decided to not measure that. And so I was like, well, so are these people experiencing symptoms to the severity of their lives being disrupted, or is it manageable? So there was just a lot of questions that this literature sort of brought up. And if I were to redo it, if I were to do it myself, I would supplement these measures that they've used, which are often self-report, so people rate on a scale of 1 to whatever, how much they experience this. I would supplement that with clinician led evaluations of post-traumatic stress disorder using gold standard measures. There are many measures that can be used to give you an accurate idea of what really the issue is.
Makes sense.
Thank you very much. Mr. McKinnon?
Thank you, Chair. I'll start with Dr. Bailey. First I want to say I want to agree with Mr. Nicholson that this evidence has been very powerful, and it agrees 100% with all the other testimony we've seen. So it's very helpful to hear the same themes coming before us again and again. I think it gives us a really good idea of where we should be going with this. One of the things that has come up many times is the idea of having counselors available to jurors during the trial. And the concern there is that in some way they might influence the decision. And also, Dr. Bailey, you mentioned designated service providers after the trial. Are these the same people, or would they be just a psychologist at large, or would that person be related to the court system in some way, some sort of an officer of the court? Perhaps you could comment on those points, sure. And anyone else may feel free to respond as well. Thank you.
And I think that the questions are related in that when I refer to a designated service provider, I think that it's important that whoever is providing the treatment services understands the unique position that they're in, that if you're talking to a juror in the midst of a trial process, which frankly could be happening with any psychologist, the juror may be in a regular course of therapy and has a session on Wednesday afternoon after the court date and is talking about a stress that they're experiencing. We need to make sure that the psychologist does not in any way influence the proceeding. So I've had trials where I've had contact with judges in the middle of the trial about what could we be doing to provide support to those jurors during the trial. And I think the support needs to simply be generic in the sense of we're going to remind them about some of the symptoms that they may be experiencing. As Dr. Lee said, understanding that some of those symptoms are normal experiences and don't necessarily lead to the diagnosis of post-traumatic stress disorder. As Ms. Lonergan pointed out, there are 4 symptoms of post-traumatic stress disorder, but you only get the diagnosis when those symptoms are causing marked distress or clinically significant impairment in social, occupational, and other important areas of functioning. As you can tell, I may have used that phrase a few times in my life. And so you can help people with the symptoms without getting into why they may be experiencing those symptoms, without needing to talk about particular pieces of evidence. And so during the trial process, there are ways of providing assistance. But again, to put that responsibility onto a psychologist or a therapist who's not part of the legal system, they may not know that having a conversation about what the juror saw the day before is problematic. So I think the designated provider applies to both the in-trial supports as well as the post-trial supports.
Would counseling during the trial reduce the likelihood of developing post-traumatic stress? I've heard in talking with first responders of the need for sort of pre-PSD therapy as well. Would this kind of fit into that category?
So again, the 3 parts, as Dr. Lee suggested, providing some education prior to the start of the process, a sort of stress inoculation approach, can be an important part of reducing the symptoms for PTSD. I do the recruit screening for the Calgary Police Service. We would be concerned about somebody being hired onto the police service who's had previous traumatic experiences. And similarly, somebody serving on a jury may be much more vulnerable to experiencing symptoms of trauma if they've had that pre-existing condition themselves. I'm not saying you exclude them from the process, but that kind of educational information may be of assistance to them. And then continuing on down the way and providing that ongoing support to them so that the symptoms that they may be experiencing understand for them as being normal symptoms. And if they become an abnormal, that marked distress or clinically significant impairment, that we're providing supports to them down the road.
Thank you.
Thank you.
Dr. Lee, would you like to respond?
In terms of the during the trial, you're right. We don't want to have someone potentially biasing jurors. But what we can do is, first of all, the education is normalize some of their reactions, because people experience things and they think they shouldn't because no one else seems to, and they feel like an alien. So it's helping to normalize that a lot of what you're experiencing is normal, and also helping them to incorporate some healthy coping skills, right? So things like even just things like deep breathing and telling yourself it's okay, and letting themselves engage in some self-care and just try to relax a little bit. Things like that, which I know sound very obvious, they don't when you're in the middle of such a stressful circumstance and think that, this shouldn't be affecting me. So it would be focusing more on self-care and healthy coping during the trial.
Okay. Thank you. Anybody else like to respond to that?
Yeah, I would agree with my colleagues and actually think that it provides an opportunity for illness prevention, specifically around, we talked about substance use and addiction. And, as Dr. Lee had mentioned, a sort of normal coping mechanism that's unfortunately very normalized in our society is, after a long day of jury duty, is to say, I need a drink, right? Or something stronger. And this is a very maladaptive way of coping with this type of stress, and can be progressive and lead to significant illness. So having those supports during a trial can sort of normalize, as has been said, what the sort of reaction is to this really dangerous environment, but then also provide other options rather than the normal coping mechanisms that many of us find, might not see as being unhealthy. And, I think that not only can that be done in a professional way so as not to bias an outcome, but actually produce better jury deliberations and outcomes, because people are actually more capable of showing up and having a good perspective in the process.
Thank you.
Thank you very much. Mr. McGregor.
Thank you, Chair. And I just want to reiterate previous comments to all the witnesses. The fact that you came to the committee and offered such concise, clear testimony, and all of you had specific recommendations. It makes it very difficult for us to ask questions, because you've really done our work for us. And I want to echo what Mr. Nicholson said, especially to you, Dr. Bailey. Like, when you come to a group of legislators and you have a clear recommendation to amend a statute of Canada, that is right up our alley. And, thank you for referencing Section 10 of the Divorce Act, because that's something that we can use as a model. I noticed that the way Section 10, subsection 2 is written, it does seem to use fairly direct language, like the court shall.
Yes.
And I note that in Section 627 of the Criminal Code, it also allows for a judge to permit a juror with a physical disability to have those kind of supports. So, when we make that recommendation to the Minister of Justice to have that clear amendment to the Criminal Code, like, are you in favor of using the more direct form of language as an example in the Divorce Act? And you touched on that too, Ms. Leclerc.
I think that without getting into the specific language, it's important to give jurors the opportunity to talk about all of the aspects of the trial. There's one point that I don't think has been brought up so far in this process, not just today, but in total. In the Derek Saretsky trial, as in many trials these days, more than 12 jurors were impaneled. But the trial concluded with 14 of them. And so the code requires that 2 of those jurors be randomly excluded from the process before the deliberations start. And one of the jurors was quite vocal in the courtroom and outside in saying, "This is a travesty. You make me sit through all of this testimony, and then you kick me out of the room before I have a chance to participate with my colleagues in the deliberation process." And so one of the recommendations that I made in a letter to the minister a couple of months ago was, there's nothing magical about the number 12. To exclude those 2 witnesses and to say, well, that makes it easier to come to a unanimous verdict, suggests that you've somehow randomly picked the 2 dissenters who would have been obstructing a unanimous verdict anyway. Why not allow all of the people to participate in the process? And so the language that we use about allowing people to discuss the deliberations is a recognition of the challenges that are inherent to deliberations. But we also have the challenge of those people who get kicked off a jury before they're even allowed to conclude the process.
And I also appreciate your earlier comments about, in some cases, we are paying jurors less than minimum wage. Less than some teenager at McDonald's is making, and you look at what they can potentially be exposed to, the total involvement that is involved in a court case. Like you said, they can't turn away. They have to give everything their careful consideration. Dr. Lee, in your testimony, you came up with some figures that really made me sit up and take notice. For example, the fact that Canada loses $6 billion in lost productivity each year due to mental health, and that for every $1 invested, we see a $4 return. We saw similar statistics when this committee was studying access to justice by making those investments in legal aid. It takes care of a whole host of myriad associated problems, and because one of the things we're struggling with is, the administration of justice is a provincial jurisdiction. But the federal government, we have our duty over the criminal code, but we also, we made a recommendation that we take a specific amount of money out of the Canada Social Transfer and dedicate it right to legal aid. Do you, looking at the financial side of things, and I'm really just trying to nail down a specific recommendation that we can make to the Justice Minister, would you like to see something similar where we have a dedicated federal funding to make sure that the provinces have a fairly even standard across this country?
I think so, especially proportional to the number of people in each province that would be serving on a jury, as long as it's not a fixed amount. So, because especially when things are starting out, it can be more of a pilot. But if you're finding that it might help to put more money into, for example, the counseling during the trial, as well as the evidence-based treatment afterwards, you might have to kind of tweak that just to see what works for long term. So it might take a while to see what is the optimal amount. But I do think this is something that should be across Canada. Why should some people in Ontario, which is wonderful that we have access to this now, get support after serving on a jury and someone, in the next province doesn't have that?
And Mr. Kylo, do you have any other comments? Because some of your testimony talked about, the investments, like if you treat it early, about how you can mitigate problems later down the line. Do you have anything else that you might want to add in the same vein of questioning?
Yeah, I mean, the $1 invested and four that really speaks to the mental health promotion and illness prevention, which is a real opportunity here, specifically where there is trauma that it will be experienced by certain people going through this process. So it's a really good investment. There's probably Dr. Lee and others could provide more specific data that could back that up for you, so that those recommendations can have that evidence. It would be really prudent. Yeah.
Okay, thank you.
Mr. Fraser.
Thank you very much, Mr. Chair. Thank you to all of the witnesses for being here today and for your excellent presentations. It is very much appreciated. Dr. Bailey, you talked in your testimony about the fact that it's pretty difficult to go through a jury trial that is really long and to not have any ability to take a break or a mental health sort of pause. I'm wondering if you know of any other jurisdiction in the world that uses the jury system where they would have that type of opportunity available for jurors to take a break.
Excellent question. I'm not aware of any jurisdiction. I can refer back to the Garland trial. And Mr. Justice David Gates went out of his way after some of the more difficult days of testimony to, on his own decision, suspend proceedings for that day and give jurors the next day off. So there were 2 breaks that he took during what was a 5-week trial. My concern would be for those much longer trials, coordinating the court schedule and giving the opportunity for jurors to take a longer break. To go to the specifics of your question, I'm not aware of that being built in anywhere else.
We heard in previous testimony from an earlier day that we were doing this study that some of the former jurors found it difficult to not have any closure of the matter. After they deliberated and there was a conviction, then it went on to a sentencing hearing, and they weren't included or made aware of what the result of that was. Are you familiar with this sort of criticism from former jurors, and what do you think we could do as a recommendation about that?
I think there are 2 parts to the process, and again, I'll use the Soretsky trial as an example. Mr. Soretsky's found guilty, but there's the issue of the parole ineligibility because it was a multiple homicide. He was potentially facing consecutive periods of parole ineligibility. And most of the jurors, but not all of them, most of the jurors came back for the sentencing hearing and sat in the gallery because for them that was something that they wanted to see, the end of the process. So some people may choose to access that, but most of the jurors will comment, and I think all of my colleagues, including Dr. Lee, would comment on the fact that jurors almost unanimously comment that, we finished, we gave our verdict, the judge came in, talked to us for a couple of minutes, told us to look after ourselves going forward, and that was it. Got my parking validated and left the courthouse. And so there isn't a sense of closure. I'll share, because I think it's relatively public information, one of the juries that I had some closer contact with, that jury gets together periodically and goes out for dinner together to check in on each other and see how they're doing. Again, it's a small financial cost to them to be able to have that kind of support from other people who've been through a similar process. Wouldn't it be nice if on a 3-month basis or a 6-month basis there was some additional support available to them for their own self-care, as well as Dr. Lee suggested, contacting the jurors to see how they're doing more generally.
And with regard to the matters themselves that we're talking about, criminal proceedings, and I noticed, Ms. LeClaire and Ms. Lonergan, you touched on the fact that obviously there's big differences between the certain, types of gruesome cases that I think we all have in mind when we're talking about this sort of program being made available. I'm wondering, Dr. Bailey, can you touch on how you would distinguish between certain cases and whether there should be a distinction made in different cases that have extra support, or is it just up to the court to do that?
I think that, as all of us have pointed out, there are some individuals who do a great job of serving on juries and have no difficulties afterwards. And there are some individuals who are triggered by something that happens during the process, but we can't know in advance what those triggers may be. And so I think most of us have made recommendations about criminal trials, civil trials, fatality inquiries. It covers a broad spectrum. Even in a civil trial, there may be such emotionality in the courtroom that there's a connection for that juror back to the case. And so to say, only in homicide trials would we provide this, or only in child sexual abuse cases, I think that's simply too restrictive.
And Ms. LeClaire and Ms. Lonergan, I know it was raised in your testimony. Can you speak to that as well, please?
I think I would agree with Dr. Bailey that it's a very difficult question to answer. I wouldn't necessarily be in favor of sort of segregating who does and does not get extra services. It could be something that could be open to everybody. There has been, like I said, the research generally supports that what we think about could cause the most problems typically does cause the most problems. But that being said, there's other research that's been shown. For example, there was one study in 1994 that showed that jurors on criminal trials involving crimes against a person were 6 times more likely to have major depression. But the same thing wasn't true for post-traumatic stress disorder. There was only one person who had post-traumatic stress disorder, and that person was from a burglary or credit card fraud case. So the field of the scope of the problem and who is more at risk in what type of trial really isn't there yet to answer that question at all. And I think it also brings up some cherry picking, like who does and does not get services. I think that there are programs and opportunities and avenues that we can look into that would provide cost-effective and therapeutically effective help for any juror that's suffering after any trial.
Great, thanks.
Much. Dr. Lee, you wanted to chime in?
So I just to agree with everyone else who's been speaking, I'd be very cautious about preemptively picking which types of crimes are likely to be traumatizing and not. To borrow from a different context, I see a lot of people have been injured in the workplace, and many times it may not look traumatic to an outside person because it's part of their job, and their employers have dismissed it and said you shouldn't be feeling this and you shouldn't be feeling trauma. But every person is different. Like everyone else has been saying, that you never quite know what's going to trigger someone, and what's traumatic for one person may not be for other people. So I'd be very cautious about that.
Thank you. So now we'll move to a question round with shorter questions. So Mr. Liepert, then Mr. Asasi, then Mr. Cooper, then back to Mr. Fraser. Okay, well, let's go with that 4. Mr. Liepert.
Just a couple of things. Dr. Bailey, just as a follow on what we were just talking about, I think that I certainly don't need any more convincing, and I'd be surprised if anybody around this table did, relative to a better information for jurors as they head into the jury duty. It seems as though some of the testimony we had, when young children are involved, it tends to be much more traumatic, and the 2 trials you referred to, both Garland and Soretsky, had young children involved. Would you suggest that maybe as part of that information package, or that information session, whatever it is, that if a young child is part of the trial, that be specifically addressed?
Yes, I think that the more specific we can make the information without biasing the process, the more helpful it's likely to be.
And you don't think that would then come back, as you said earlier, where I think, is it the Soretsky trial, one where you said that the
Garland
trial, where they're now using it against?
And I know defense counsel in that case quite well. I don't think that, in my view, and I don't mean to prejudge the Court of Appeal, in my view, what Justice Gates was doing was looking out for the mental health of the jurors relative to the evidence they were hearing about the victims. that evidence didn't necessarily point to this accused as being the perpetrator. And so when you provide information for the jury that says there is a child who died in this offense, unless there's some dispute about whether or not the child died or simply disappeared, we know that there is a child who died in this, or it was the child who was a victim of sexual abuse. And so I don't think that, in my view, that it biases the jury to say this is the type of testimony that you're likely to be hearing. And again, as all of us have said, reminding people of their natural resiliency skills, monitoring their sleep, monitoring their appetite, getting a regular workout in, maintaining their social contacts, restricting their consumption of alcohol and other drugs. I don't think that that creates a bias.
Just a quick comment, Mr. Kylo. We've had, one more thing. We actually had one of the kicked out jurors as a witness, which was very helpful, because I think, again, that's a real issue that somehow doesn't seem that difficult to solve. Mr. Kylo, just a quick comment, and it's not criticism, but some of the testimony we've had seem to indicate that Alberta has had in place for a long time kind of the most progressive program, I guess is the way I can put it. Right. And yet in your remarks you made no mention of Alberta. You mentioned Ontario and Manitoba. Is the Canadian Mental Health Association familiar with Alberta's program, and is it one that might be modeled by other provinces?
Absolutely. I would suggest that it would be probably one of the best practices out there. I mentioned Ontario and Manitoba because they're less known, and I would have assumed that you've heard quite a lot about Alberta's programs to date. Yeah.
Thank you very much. Mr. Asasi.
Thank you, Mr. Chair. I, in turn, would like to thank all of you. You've been incredibly helpful. And given that it is getting pretty late, I'll keep it very, very brief. Dr. Lee, if I could first ask you, you obviously have a lot of experience dealing with first responders. So is there any legislation, policies, code of conduct that applies to first responders that we could graft and use when it comes to jurors? Is there anything that comes to mind?
So services vary widely across Canada in terms of what they offer their staff. What I've seen is, so I've been a trainer with York Region Paramedic Service, so I'm going to use them as an example because I think they're doing a great job. So with all their paramedics, I'm actually one of their clinician trainers for a resiliency mental health preparedness program. So they're just going in, and with all the new recruits and all the seasoned staff, they're just talking about what are some of these operational stress injuries that people may experience, what do they look like, what are some basic coping skills. Here's some numbers that you can reach out to, or some of our staff to reach out to if you're having problems and it's confidential. So they're going there proactively, and they also have a peer support team, which isn't as feasible with a jury, but even having some kind of, we've been talking about whether it's a mental health support person or a clinician or someone that they can reach out to during the trial and afterwards, I think would be tremendously helpful.
Thank you very much for that. And now if I could turn to Dr. Bailey. First question was, you alluded to the numbers for Alberta as to the people who actually are seeking services, and it really seemed quite minuscule. Would you possibly have costs for other provinces as well?
I don't, because I don't know what their utilization is, and there's also been different dates. I mean, Saskatchewan introduced their program last week. Again, a 4-session, 2-month model, so I don't imagine anybody's taken advantage of it just yet. But in other provinces, I'm sure that those numbers would be available through the mechanisms that they've set up, such as an employee assistance program.
Okay. That's something we should definitely look into. Thank you for that. The second question I had for you was that you talked about information that should be provided beforehand, but you only alluded to two things, if I was listening correctly. The two things you were talking about were the mechanics and compensation and things of that nature. Could you elaborate on that? What else would you include in those kits that are handed to jurors beforehand, before they?
And I think the other critical piece that I hope I alluded to was the resiliency component of the things that jurors need to do to be looking after themselves during the process. So the finances and the mechanics are the things that allow jurors to have some sense of control over what's going on in their lives. When people don't feel control, they tend to experience higher levels of anxiety. And so if you give them that information, they have a little bit more knowledge about what to expect, again, in terms of the mechanics. But jurors may not have a great deal of sense of what to expect in terms of the emotional testimony. Again, going back to the Garland trial, we had a medical examiner who was tearful on the stand, an experienced professional who's struggling with the evidence that she's being asked to present. And so to have jury members who don't have that experience, to just provide them with some information up front that says this is the kind of difficult testimony you may be experiencing. These are the kind of symptoms that you may be experiencing. Those are normal symptoms, and these are some of the strategies that you can use to ameliorate those symptoms during the trial process, and these are the supports that are available to you afterwards.
Thank you. And is this something that's currently done in Alberta?
There is a brochure that's provided. I think that it could be more comprehensive. I think the program generally could be more comprehensive.
Would you be kind enough to actually send us a copy
Sure.
of that to the
Certainly.
committee? And do you know if any other province also has a similar practice?
I believe that there is information provided to jurors in other provinces, but I don't know the depth of that information.
Asked for all the brochures. Alberta has mentioned it in their own testimony. Ontario has it. The Yukon has it, and we've asked for it from all the provinces that have the program. Thank you, Mr. Cooper.
Just a question to Mr. Kylo. You alluded to the Manitoba debriefing program. We really haven't heard much evidence about that program. I understand that it was established in 2005, but other than that, I really don't know much about it. I was wondering if perhaps you could elaborate on what the Manitoba experience has been in terms of a debriefing program. The second question that I would just ask Dr. Bailey, in your experience in counseling jurors, you mentioned that a number of people who've come to you were perhaps not satisfied with the 4 counseling sessions or required further assistance. One of the things that I was quite surprised hearing from Alberta and Ontario was the relatively small number of jurors who are accessing those programs. And in addition to that, I was surprised that in terms of the 4, I think in Ontario it's up to 8 counseling sessions that are provided, that almost no one who has accessed those programs have asked for more sessions. Do you have any theory as to why that is? Is it a lack of information? Is it perhaps jurors who are discouraged in some way? It just seems a little bit surprising, having regard for some of the statistics which show that PTSD and other stresses are quite commonplace compared to the number of people that are actually accessing these programs.
And I'll give Mr. Kylo the chance to answer the debrief program.
Yeah, I would actually love to be able to provide some follow-up information. The executive director of CMHA Manitoba and Winnipeg, Manitoba Division Winnipeg branch provided me with the background details of the programming going on in Manitoba, and I'd love to forward that to the committee.
There was a witness in January. They weren't available before Christmas, but hopefully they'll be here after the new year.
Some of the concerns that have been raised by the jurors who sought me out is not feeling a sense of connection to the therapist that was provided through the juror support program. As I mentioned, I'm a forensic psychologist. The last line of my bio for any presentations is Dr. Bailey appears frequently before the courts, usually as an expert, and only occasionally as an accused. And so I'm used to being there. I understand the processes. I understand that, even something as simple as the layout of the courtroom and where the jury rooms are and the parking difficulties at the courthouse. And so jurors, I think, feel sense of connection and an opportunity to talk about their experience with somebody who's been involved in the process that, frankly, some of the counselors in the programs may not have had. They may be brilliant counselors or therapists, but without having the legal background or the courtroom background, don't understand. So when a juror says, yeah, they did a voir dire and we were off for 3 days, and the counselor's like, well, what's a voir dire? Kind of interrupts the counseling process that the juror now has to do the educational part of it.
Thank you. Dr. Lee, you wanted to intervene?
Yes, I just wanted to make a corollary to what I've heard a lot from first responders is that, you know, almost every service has access to their Employee Assistance Program, EAP. And so I hear so many stories of people trying to reach out to their EAP counselors, and they find it very frustrating, and they only go once or twice because similar to what Dr. Bailey is saying, many of these counselors, they don't get it. They don't get trauma. They don't understand cumulative trauma. They don't understand trauma that's part of someone's work or duties. So they find it very helpful to speak to someone who really understands what that world is like and what the impact of cumulative trauma is.
Thank you. So I had a couple more short questions. Mr. Fraser and then Mr. Boissonnault. Mr. Fraser?
Sure. Thanks, Mr. Chair. Mr. Kylo, if I can ask you a similar question to what Mr. Cooper asked about the debriefing program, and I understand that they have that program in Manitoba. We'll receive that information. But what, in your opinion, would be a model sort of type of debriefing session post-trial? And do you think it would be better to have an individualized debriefing session with each juror, or whether it be a collective sort of thing?
It's a very good question. I've got my own personal sort of thoughts on that, but I'd probably defer to my esteemed colleagues who might be able to sort of provide a more professional opinion on that.
My more professional opinion is both.
Yeah.
I think that they're both. So as a group, this is a 12 jurors, 14 jurors who've been through a process. And so in the same way that we do debriefs with first responders who've been involved in a critical incident, there are appropriate ways of doing that, some criticisms of some inappropriate ways of doing that. Allow the jury to vent as a group about some of their experiences, but then follow up with those who want the individual follow-up, or at the very least touch base with them. So again, undercover police units, we talked about people viewing graphic images, so the homicide units, the integrated child exploitation units. We do mental health checks with them on an annual basis. And somebody may come in and see me for 10 minutes and say, no, I'm doing okay, thanks for checking in. And other people may say, oh, I'm so glad that this is a regular part of our routine because now I get a chance to tell you what's been going on. And so I think you do the same thing with jurors. And if somebody says, no, I'm good today, but I appreciate knowing what the supports are for me down the road if something comes up, then that's another opportunity to reinforce those supports.
Dr. Lee, did you have any comment on that?
I absolutely agree. So this kind of debriefing or check-in can certainly be done as a group, where if members do want to talk, I mean, you want to be careful that people don't go too much into trauma detail, because that can be very upsetting for other people in the group. But just to give some education about here's some symptoms, here's what can happen down the road. You know, anyone want to talk about how they're feeling, and then, you know, here's the number, call us if you want. So you can do it as a group, but then, as Dr. Bailey was saying, follow up individually.
Great. Thank you very much.
Thank you. Mr. Boissonnault.
Thanks, Mr. Chair. Thanks to all of the witnesses. We will listen to more witnesses. We will write a report. We will recommend some money. Hopefully the money gets found. It gets to the people who need it. Are there enough people to provide the supports, who have the expertise that Dr. Lee and Mr. Kylo and you have outlined is necessary to provide the proper care? Or are we setting ourselves up to create a demand for which we don't have the supply of professionals, is the first question. Second question is, we told military people in the past to suck it up, tough it out, push it through, and that didn't work. We did the same with first responders. That didn't work. And so now we're doing it with jurors. So my very basic layperson question is, are we asking too much of jurors? Or is it just we're asking too much of jurors without the proper supports in place? Anyone can respond.
Well, I can go first. In terms of, is there enough clinicians? If if this rolled out across Canada tomorrow, there probably wouldn't be. But certainly this is something where there is a lot of interest, and more people have been getting trained in the appropriate types of trauma treatment, with all the focus of veterans coming back from Afghanistan and increasing recognition of first responders and what they go through. So there's certainly opportunities for training that could be put into place fairly quickly. So it couldn't happen tomorrow, but it can definitely happen over time.
And I think that we look at, as Mr. Kylo commented, the occupational stress injury clinics that most provinces have available to them. Those are going to be a number of professionals who are trained in trauma. Again, 20 jurors in the 2 years that Alberta's had its program. I would certainly hope that we're able to provide that number of resources. One of the challenges comes when jurors come from more remote areas. But we have the wonderful technologies these days that allow for coverage to be provided to those groups as well. So I agree with Dr. Lee, probably not tomorrow, but in a very short period of time, each province should be able to recognize quality professionals, psychologists, social workers, and other individuals who may be able to provide the services.
Thank you, Ms. Lonergan.
There are other treatments that are currently being developed for PTSD. In our lab, we work on one, which is, well, it's complicated a little bit, but essentially it's trying to dampen the emotional tone of the traumatic memory to alleviate the symptoms. We've been working on it for about a decade, and what's really fun with it is that we get similar results to evidence-based treatments right now, but we do it in half the time and at half the cost, and with students who could be trained right out of undergraduate student, because it's a very easy treatment to implement. So these types of things are coming up. It's still in the experimental phase. It's not widely used right now, but these things are coming up too. That, hopefully, it's our sort of hope is that in the near future it becomes something that's more mainstream and that more people can be trained in. We can reach a lot more people.
And on my question of, are we asking too much of jurors? Anybody want to take that on?
Tell the story. I was involved in a trial back in 1996 and was sitting with a number of the lawyers after the trial was over. And one of the lawyers talked about a previous year in which he had done 12 homicide trials in a calendar year. It simply doesn't happen anymore because of the complexity of the voir dires, the charter challenges, the admissibility of evidence. And so we then, in a complicated trial, asked jurors to be beyond a reasonable doubt on certain facets, but on a preponderance of possibility on other evidence. We have made the process very complicated, but I think the most complicating part is the length of the trial. So in the good old days, a homicide trial was 3, 4, maybe 5 days long. The Daniel McNaughton trial, the infamous insanity case trial, was a 3-day trial. And so now we take these trials and put them out over 5 months or 10 months, as you heard from the witnesses 2 weeks ago. That increases the repetitive exposure to this gruesome testimony, to the evidence, to the videos, to the physical exhibits, to the testimony. That makes it much more demanding on juries, and I think gets to the point where we are expecting too much of some individuals.
Thank you all very much.
Thank you very much. Any other questions? Not seeing any. I want to thank our group of witnesses from today. As all of my colleagues have said, your testimony has been very helpful and very instructive, and clear recommendations are always appreciated. So thank you so much, all of you, for coming and for testifying online from Toronto. Meeting adjourned.